Secretary of State, I'm, like Baroness Berridge, a new member on this committee, so can I say the absence of accurate figures, of course, is a huge issue because it's harder and harder to judge. But phrases, that saying that immigration has plummeted or the problem solved, it's not, because all we're talking about is net figures. The gross figures, which were the ones, if we take to March 26, there was 813,000 people come into this country. Now that included boat people and so on. That is a colossal number of people. Now what we don't know is what their economic status and demand for public services is via the 643,000 people who left. So the net figure is totally misleading. It doesn't tell you anything about the demands on public services or the economic status of the people who have arrived. But to say that it's sorted, I mean, they used to say that the first thing a politician should learn is to know how to count. And we don't know how to count in this country and haven't done for 40 years. So I just wanted to know could you give us a timetable as to when do you think we would have information that would be of sufficient quality to be able to judge what the implications are on these colossal numbers, which is, even at this stage, 16,000 people a week?
So, I mean, there's different figures in there, obviously, but let me say, just on the specific question that I know has been of interest to the committee before on exit checks and the numbers, the best proxy that's been used is numbers in and then what you know from your exit checks to work out what your potential population of overstayers is likely to be. The reason those are proxies are again, issues I think the committee knows well, because, of course, the way that the common travel area works, dual nationals, there are reasons why you can't have a definitive figure. And, of course, we are a relatively open society. We don't have a system of compulsory ID that is used to check status on a regular basis. And, the government's work on digital ID is about ease of use of public services, not, gateways to check people's status. So, that for the sort of country we are and how we run ourselves, that ability to give you like a definitive, this is exactly the number today, is not possible. What you can get is a good proxy that tells you what your population of interest is, and then also tells us what we can do in terms of immigration enforcement. So we do know when we think someone has overstayed, and then we are able to tailor immigration enforcement in that direction. Overstaying in and of itself hasn't been a big priority within immigration enforcement work before. That has changed under this government. We've obviously increased resources for immigration enforcement. I think the footprint for immigration enforcement now is going to be the biggest it's ever been, and that creates more capacity to be able to both make our very good progress on removals of foreign offenders, keep going in the right direction. Our numbers are higher than those that we inherited, to be able to do more on removals of people who are failed asylum seekers, and then also to be able to go after a bigger cohort of overstayers as well.
Thank you very much. Now, can I just say to the Secretary of State and to all colleagues, time is really up against us, so short questions, short answers for now, so we can get through everything. Since I want to ask the next one, which is about the Life in UK test, I'm not going to ask the Secretary of State a whole series of difficult questions like how old is Big Ben, questions that seem to us totally irrelevant to life in this country. So can I just ask you, Secretary of State, first of all, we've called for major reforms. You've said you're going to do something about it. Can you tell us what progress there is? And secondly, we also suggested you should look very seriously at a different way of doing it, which is the sort of support mechanisms of that they have for people who've done bad things and have been sent off to a driving offence course, and there should be similar things like that. Could you just very quickly tell us what progress is being made and what do you think of our course proposal?
So I hope to be able to update Parliament, the House, more on proposals in this area later this year. The contract for the current test, I think, runs out in autumn of next year. So there is a good moment coming up where, if we want to do things very differently, we can do. I would agree with you. I actually bought my copy, by the way, just in case I needed a quick cribbing. And then having looked at, I mean, anyway, there are...
Knowing you had, that's why I didn't ask you the questions.
Not test me. I would have offered to test each of you in turn as well. But no, I think, look, I take on board the point. I would just observe, I think any system of testing, you know, that you have got across what it is, who we are as a country, and that this is the choice you're making as you become a citizen of our country, is likely to feel a little crude, because it's not you know, it's not a thing that's easy to test. You know, if you're coming to this country, you're joining a very particular kind of society with very particular norms about how we do things, and it's very hard to just get on one piece of paper the inheritance you have.
I am going to stop you.
I agree with that,
State.
but we will find a better way than the way that we have at the moment.
Can I just be absolutely clear? First of all, you have said that the contract doesn't run out for a bit. It is perfectly possible, is it not, to make changes to the current questions in the current system straight away. It cannot be right to have at least 2 questions in the system where the answers, the correct answers, are actually wrong. Okay, I mean, for example, King Canute was not the first Danish king, it was Svein Forkbeard, and it is not true to say that the highest value of the UK note is £50, when if you go to Scotland you can get a £100 note. Just assure us that changes are being made now.
So let me come back on the specifics of the wrong questions. I have asked, I mean, you'll be pleased to know, in terms of the integrity of the test, not even the Home Secretary can see the questions. So I will have to defer to officials on the checking of the accuracy of the answers. And I'm very happy to write to the committee on those 2 specifics. I suspect 1 or 2 of those might be contested, though, anyway.
And on seriously looking at our proposal for either an alternative or something that is an optional extra, looking at courses along the side of the very successful things that are done with the driving offence people.
We are absolutely looking at proposals that have been made, previous findings from this committee and others, seriously. We're also looking to learn from other jurisdictions as well.
Thank you. That's very helpful. Lord Bark.
Very, very quickly, Lord Chair, because there are a couple of people who want to ask supplementaries on this question. So I've got the Immigration and Asylum Bill just been introduced. The simple question is, what's the most important impact you see this having, Secretary?
Well, I think that it will be crucial to helping us get some measure of control on a system that is failing very badly at the moment. Very specifically, I think that it will, with the new independent immigration appeals body, help us to help us to get to grips with the very big problem that we see in the immigration appeal space, which is just the sheer volume of appeals. I think demands a new public policy response to be able to handle that volume. So we've seen initial decisions made much more quickly. We've got through that backlog more quickly, but everybody's just basically ending up sat in the appeals backlog instead. So I think that is, in terms of being able to more speedily decide cases and get people to point of removal, I think that is one of the biggest changes that will have an impact on this space. There's obviously other important changes on Article 8 reform, making sure human rights legislation and the development of human rights here doesn't take us beyond our international obligations. So, you know, we are within our international obligations, which we care about and want to maintain, but we're not going further than we need to in terms of fulfilling our obligations. So, you know, I think there's a strong suite of measures of the ones that I think it will take some time, but the biggest impact is on immigration appeals.
Thank you.
Lord Dubs.
Home Secretary, it's a pleasure to be able to put the question to you directly as opposed to via the media. You scrapped or you suspended family reunion last autumn, and when this bill came along I was hoping there'd be something in it to say it was coming back again. I'm talking about family reunion where there are children abroad who have family here. What's the chance of you bringing something like that back again?
So we have not yet settled policy on family reunion. It remains suspended, but we have committed to settling policy on family reunion and separately on children. None of the changes we have made impact on unaccompanied minors in the country. The rest of the cohort, we've said that we will settle policy, and we expect to do so later in the year.
Thank you. And one very specific question on the bill, Lord Anderson.
Yes, thank you. You've alluded to the Independent Immigration Appeals Authority provided for in the bill, which will see judges of the first-tier tribunal replaced by adjudicators who won't need to be lawyers, although they will, of course, need to be recruited and trained.
Yes.
I know your aim, as you've said, is to increase capacity and speed up decision-making, but your published impact assessment rates the value of this change as uncertain, and the Public Law Project has said you're prioritising speed over justice. So really two questions. First, how do you answer those criticisms? And specifically, can you clarify whether these lay adjudicators will have access to legal expertise, rather as lay magistrates have a magistrate's clerk in their court, or will they just be left to get on with it?
No, they will, so I can deal with that quite quickly. Intended in exactly the same way as the situation in the magistrates' court, although of course the big difference between these adjudicators is they will be trained, so not sitting as ordinary members of the public, but recruited from a broader range of people. And then, look, I think that when you have a system that is not able to deal with claims in a speedy way, or where last-minute appeals are able to frustrate legitimate removal from the country, I'd question whether that's meaningful justice as well. So I don't accept that criticism on speed over justice, and I actually think that speed and the ability to have flex in the when it comes to the sheer scale of immigration appeals that we see is necessary to maintain justice in its broadest sense, which is not just for the people who are awaiting a decision, awaiting a hearing on their appeal, but also for everybody else, who's got a public interest in knowing that the government can, remove those who have no right to be in the country, and to do so effectively and quickly without last-minute frustrations that are designed to frustrate legitimate removal from the country. So I think I reject that criticism. I think we can get the balance right. It will still be an independent chamber. We set out in legislation the independence of the individuals that will run that and have oversight. What it does allow is for a Home Secretary to be able to ask the chamber to flex so that they can prioritise cases based on a wider public interest. That is different to the way that judges do listings in other tribunals. As a former Lord Chancellor, I would never interfere with listings for the judiciary. They have a specific set of things that they do for us constitutionally. That's not for the government. But here, when it comes to immigration appeals, I think the ability to be able to flex that system to prioritise in the public interest, to make sure you can get foreign offenders out of your jurisdiction, those public interest requirements matter more, but there will still be a legal independent underpinning, and ministers will be required to uphold the independence of this authority as well.